Okay, and we are on recording. So just a little housekeeping items. We will have public comment at the beginning and the end. So you have the option to raise your hand, or if you can turn on your video and kind of wave me down, I will call on you so you can participate in public comment. So with that, just to get things started, it is September 16th of 2021, and we will be going over the notice of adoption for LCB file R011-21. So this is a hearing with the intent for adoption, but of course we'll be taking comment as well in consideration. For the record, my name is Ashley Jepson. I'm the Plant Industry Administrator with the Department of Agriculture, which is now the Plant Health and Compliance Division. So just to go over a little bit of the agenda here, we will start with public comment. We will go in with a brief overview of the context of the proposed regulations intended for adoption, and then we will open it up for public comment again as well. I wanted to just give a little context as this process, especially for folks that are jumping in a little bit later. We started doing workshops well over a year ago that started under R145-20. Due to the nature of the legislative year, we did move forward with temporary regulation adoption so we could have a state hemp plan approved, and that folded into temporary regulation T001-21. So I believe at this point we've had 4 workshops involving these specific regulations, and they've continued to evolve. Now what we're trying to do is adopt those temporary regulations and make them permanent so that we can continue with our state hemp plan. For a little bit of context there, in order for a state to have a hemp program and to have primary regulatory oversight, we have to have an approved state plan by USDA, and with that there were several regulation additions, language changes that we needed to encompass in order to get that plan approved, which is exciting. We did get the plan approved in May, but to maintain that, we're under a crunch to get these regulations adopted. The temporary regulations expire November 1st of 2021, so we're trying to get this hearing in so we can make it to the Legislative Commission hearing and get these adopted. There have not been really many changes at all since we had our workshop in June of 2021. So fairly standard. We had a couple little tweaks with language, mainly there were a couple things that passed through this last legislative session. But just for kind of piecing things together, I wanted to give some context. So with that, I will also one other housekeeping item. It looks like just about everybody that I can see has their name in. There's one Marla M.W. If you're able to change your name so we can actually have that for the record, we do have to maintain a list of folks that are attending. That would be absolutely fantastic. I'm not seeing anybody on outside of that, so I think we've got enough names that we should be in good shape for our record. But if you're able to update your name to have your first and last name, that's absolutely wonderful. And with that, I will stop talking and we will open it up for public comment. Again, you can raise your hand with the icon, or you can, if you're on the phone, I believe it's *6. Please correct me, Sierra or Audrey, if I'm incorrect on that, and you can unmute. We do ask folks to limit their comments to 3 minutes in respect of other participants as well. And if you're having any technical issues, you're absolutely welcome to send us comments via email. We'll make sure that those are encompassed in this hearing or any other form of correspondence. So with that, we will open it up for public comment. I'm not seeing anybody at this point. We do have opportunity at the end. I'm just going to, just in case, give a couple more minutes. Second, I should say. Thanks, Alan. Alan also put in the chat if you have any written comments you'd like to submit, you can email them directly to him, and he has in the chat his email. It's also on the notice on our website, his email as well. And of course, if you have my contact information, I'm happy to share that as well. Okay. All right, so we're going to jump into an overview of the proposed regulations intended for adoption. So bear with me for a moment as I share my screen. Visuals go a long way. Okay, I think we're on here. Just a little bigger. Jump through it. I know folks have commented size has been an issue in the past, so I'm just going to try to tweak it a little bit. That might help. Okay. Let's jump in. This is LCB file number R011-21. And I'm just going to do a high level overview. So just again, for context, the changes that we have made have primarily been incorporating definitions required by USDA in order for us to have a state plan approved, and also to get our regulations up to par with the final hemp rules in order to have that primary regulatory oversight. So you'll see a theme throughout this regulation that we are referencing CFR. There's been a lot of changes in the program. It's still new, it's still progressing. So we want to be able to quickly adapt to those changes as the program progresses. So we're referencing CFR for the most part throughout. Sounds like we might be having some technical issues that somebody was trying to for public comment, but we'll have another opportunity at the end to try to get that situated. And you can also enter it in the chat as well. Okay, going into kind of the meat here of the regulations, jumping past the legislative digest here. So in these initial parts of our the draft, it is one of the key things we had to do was define acceptable hemp THC level, and so that encompasses not only that the THC content needs to be reported, but also that it needs to reflect the lab's measurement of uncertainty. So we also in this this regulation, we're adopting a definition for measurement of uncertainty, which reflects the federal rule to make sure that our lab is following these requirements and that we're getting those reports out to those that are participating in the program. Same thing here, we're defining key participant. That was some really key language in the interim rules on some of the things they want to see for background checks, but there's since been more flexibility, which we'll go into. So as I mentioned, Section 5, Section 6, those are all really just updates on what specific definitions are as you're navigating through. So a registrant is a grower, handler, producer, measurement of uncertainty, we're leaning on that CFR. One thing I definitely wanted to take a moment to highlight here, we had 2 Senate bills go through this last legislative session, and one of them it was through 453, NAC 453, which is the Cannabis Compliance Board's regulations, and they updated the definition of THC. So you will see that update towards the end of the document, but it does encompass other cannabinoids and isomers that we're seeing pop up where folks are trying to circumvent some of the THC limitations and hold potential for getting psychoactive material out there. So you're going to see that it is mentioned here as well. So really in these initial sections, it's the contact information that we need, the physical location, all the things that need to be on the application per the federal requirements, and for us to be able to confirm that information to meet those federal requirements. So with that, it comes with background checks. It comes with making sure that we have a legal description of the property and location, so geospatial location. So it's really bulleted throughout here on the things that we need to see in those applications, and gives discretion to of anything additional that might be needed, so that we can actually determine whether somebody meets the requirements to grow hemp. So it also just with this comes some reporting requirements that the department has to do with USDA. So we have that laid out of what the expectations are of our applicants here in this section. It also goes into that FSA reporting, which we've talked about in previous workshops. So there's information that does have to be reported to FSA. That's also comes into play for crop insurance. So it's actually very important for that information to be registered, and that's detailed here as well. Criminal history report, we've covered this quite a bit. A criminal history report does have to accompany the application for somebody interested in producing or handling hemp. With that, we've been working through that. I know a lot of folks were having some issues navigating that process over the last year, and I think we ended up in a really good place. So we did get approved that 120-day buffer between when somebody gets a report and when it can be submitted to us. So hopefully that's working for folks, and that is in here and is more flexible than what we've been seeing elsewhere. So also here, one key thing that we've talked about and presented is that applicants need to demonstrate that they're in compliance with federal and state laws. We have seen run into some really big issues with our other state agencies that have been of concern involving use of water rights, use of land that's properly zoned, and misuse in those areas. So we're really trying to get ahead of those things to make sure that all those requirements are being met, so that somebody isn't issued a license that then is later more difficult to address issues. And a lot of this, I mean, it speaks for itself. The application needs to accompany fees. We'll talk about what fee changes have taken place with this towards the end of the document and what has remained the same. One critical thing that we also added is materially falsifying information. Unfortunately, we have been encountering this issue where folks are submitting false information on their applications that would have deemed them ineligible. So just making sure that we've got some better grounds to make sure that this program remains reputable. Okay, sorry, here, section 9, going into that criminal history report that I referenced before. So essentially, if somebody has been convicted of a felony of a controlled substance, they're not eligible to be a grower, handler, or producer for 10 years after that date of conviction. There is an exemption here if they were lawfully growing under the 2014 Farm Bill. However, that is essentially what we're looking for with those background checks and our requirement. Just for context, I think most of you already know that, but USDA did provide clarification that a state background checks at this point suffices. So we have it in writing. It's been an easier lift for our growers, so we've been accepting that at that point in time until we're told otherwise by USDA. Okay. Section 10, this was something that came up during our 2019 legislative session and was discussed during this workshop series. There is provisions that would allow for the transfer of somebody's registration, but we really needed to spell out what that entails, and it does require time and review. So we have here the conditions for when somebody can do a transfer. If you're transferring it to somebody, clearly the background check information applies. we need to make sure that all the I's are dotted and T's are crossed. And it can't be for a new location because that really is a completely different request and would necessitate a new application. But that's clarified here as well. And again, you need to have that criminal history report for it as well. Okay, moving on to section 11 here. This is, I mentioned this previously, but really spelling out some of the information that absolutely needs to be on the application. This isn't really anything different than what's been done in the past. It's pretty straightforward. So that's spelled out here: acreage, location, street address, mailing address, and physical location where the crop is taking place. And then that Farm Service Agency reporting, I apologize for just using the acronym earlier, is a requirement of USDA, and we do have to have that provision. And we've been trying to work with folks to be successful in that regard. Moving into section 12, this is the critical piece of being able to inspect, sample, and analyze the crop. That's a key piece here. We're trying to differentiate, make sure that the cannabis is not marijuana, is not that psychoactive material or circumventing marijuana regulations in the state. So that's where the inspection of crops, the tracking, the sample, and the analyzing is really, really critical. So allowing us to have access, which has been the case in the past, but just fine-tuning that a little bit more in terms of language. Trying to make it definitely more clear for folks too to navigate these regulations. So allowing us to have access to buildings, structures, and so forth. Notification before, this is stuff that our previous registrants have seen. We need to know when harvest is intended to take place so that we can get out there and sample. And that also applies to if a crop does not pass compliance, if there needs to be remediation and sampling for that, ensuring that those things, that notification is happening beforehand and things are not entering stream of commerce that have not been tested and proven to meet requirements. Section 14 just really spells out the testing requirement that must take place. There needs to be conversion of THCA to THC using a post-decarboxylation method or similarly reliable. That really needs to be clarified here. It's been in the federal law, so it's here as well. And making sure that we have that procedure in place. See. Just for record, the Department of Agriculture uses total potential THC. So we do use the equation for that, and that's our method, and that's been an acceptable method for USDA. Okay. Stuff is fairly self-explanatory. There's been a lot of discussion on the measurement of uncertainty and how that is calculated. So we've had a lot of discussions with USDA. We've reviewed the final rules very carefully, and they specify in there that the method needs to meet these specific requirements. So standard method performance requirements for quantity of cannabinoids and plant materials of hemp. And that we will reference this method. So we did have to spell out the method that we'll be utilizing. That also helps with transparency and how that determination is made on the measurement of uncertainty. It does need to be specific to a lab and what they're finding in their samples to actually have a range of where they feel there's a measurement of confidence that the sample falls within that range. It can be a little bit complex, so if folks have immediate questions on that, we're happy to share that. We do issue a letter in advance specifying what that measurement of uncertainty range is and what would be accepted, and that's also required to be on the sample analysis that goes out to the producer. Okay, section 16. So one of the things we did see transition from our workshop and our adoption of temporary regulations is the final rules came out, and one of the great shifts that they had in those final federal rules was a remediation option. So this has been updated to make sure that that remediation option is here, that we're referencing CFR, and that is an option should a crop exceed the acceptable THC level, to then go to that next method to see if we can get it where it needs to be, so a crop doesn't have to be disposed of. That's the last thing anybody wants. So just for clarification, that has been updated here. If the sample does exceed the acceptable hemp THC level, producers have multiple options. They can opt to just dispose of it, which might be more economical than the remediation option, or they have the remediation option. But those all have to be overseen or resampled and so forth. That's just being spelled out here. Negligent violations are what we address in section 17. Again, that's a federal requirement. So essentially, if we have violations involving somebody not being registered to produce, doesn't give the legal location or pledged the facts on the legal location, or if they've continued to exceed 1% post-decarboxylated THC on their testing, that can put them in that negligent action too. So there's, I believe the limit has been 1 per year. So if there were repeats crop samples that exceeded that, it's not going to give them 3 strikes in a year. But once you do get to 3 strikes over that time, the producer will be out of production for 5 years. And again, that's a federal requirement. Should negligent violations take place, a corrective action plan is required, and to detail how that's going to be mitigated, it also requires that there will be annual inspections and reporting on activities. Section 19 really gets into the fees for service. So there were some fee changes. So we did hear from industry. We do have a handful of nursery licensed producers for hemp. They do pay a fee currently of $175. So based on that, since they're paying a nursery fee and we have inspectors out there, we do try to use our staff as effectively as possible on those site verifications. So their rate was $725, since the cumulative between their nursery and their hemp license would be $900. And that is the same that is just for a non-nursery certified producer as well. It's increased from $500 to $900. And again, that was really having to do with our federal requirements in meeting and the activities that have to take place by our staff to meet those. It's a lot of manpower, it's a lot of tracking. And so that's where that comes from. The square footage and per acre fee is the same as what it has historically been in the program. The same thing for the handler license. The only other increase we had, our hourly inspection fee increased from $50 to $60. Same thing to cover the costs of staff being out there. We try to be as efficient as possible and overlapping our inspections when they're going out to an area. So we always encourage that advance notice so we can try to save our time and your resources as well. The only other fee that we have included is if there is a licensure change or revision, if somebody is trying to transfer something, just to cover the costs of doing those reviews and issuing a new certificate, there's the $150 fee. Okay. Our fines and civil penalties are the same as what they were previously as well. I think that's really the meat of it. The only last thing I wanted to draw attention to is section 21 is where it draws in that updated definition of THC that took place in NRS 453139, which again is what the Cannabis Compliance Board utilizes for their authority, and we reference THC as well to make sure that we're working in harmony. So part of that bill specifically was trying to address synthetic THC and other THC isomers that are trying to circulate or circumvent, excuse me, the federal requirements. So that's been updated here as well to make sure that folks are falling in that same percentage line. So if it's 0.33 that they need to fall under for Delta 9, it would be the same for a Delta 8 and so forth. Okay, I know that was a lot. I did have to go through the nitty gritty, and I know you guys, from what I can see, are in attendance, are fairly well versed in these. So thanks for bearing with me. If you're reviewing and you should have any questions, of course, please reach out to us. We're happy to provide that. And I'll also just thank everybody. You know, there's been a lot of involvement throughout these workshops and to get us here. And it's really, truly appreciated. Having an extra set of eyes, knowing perspectives from industry is huge. So I just wanted to make sure I took the time to thank you all. So with that, I will stop talking and we will open it back up to public comment. Let me stop sharing here. There we go. And thank you, Alan. If you are going to speak, please be sure to state your first and last name. Thanks, Alan. I hear a little in the background. Joe, is that you?
Yep, that's me, Joe Frey.
Okay, let me mute myself here and you've got the floor.
Okay, I just want to say thank you for all you guys' work. I think what you guys have has turned out pretty darn good. I appreciate it all. I know it's been tenuous at times, but I think we've got something pretty good here.
Thanks, Joe. That's really appreciated. Tried. So thank you. Okay. See any other folks that would like to speak? Marla, it looks like you've tried a couple times. So again, if there's some follow-up that you if you still have some issues that you want to send in an email, or we're happy to take that.
Hi there, this is Cheryl Marie Powell, Esquire. I'm a cannabis agricultural and dietary supplement attorney. So I've worked with states and municipalities on hemp as well as marijuana legislation. I just want to say that you did a great job complying with the Farm Bill. Awesome work here. I also am a business development manager for Creative Services, Inc., and we do background screening for departments of agriculture, for cannabis commission, so we are available as a resource. So I just want to congratulate you on this draft. Well done, and great changes just to align with federal law.
Thank you. Appreciate that. All right, do we have any other public comment? Also, Audrey, if there were anything that I botched or overlooked that you wanted to draw attention to, feel more than free to chime in as well. They're not necessary, but should there be anything you want to clarify on?
Yeah, Ashley, yeah, I think you covered it quite clearly. And if there is any follow-up, I'm happy to help answer those questions as well. And we do send out communications to our growers. So shortly another communication will be going out for the end of the year, and some of these things might be addressed in that communication.
Thanks, Audrey. Okay, anybody else that would like to speak? Sierra, have I missed anybody else? I'm not seeing anything else in the chat. Anybody else that wants to chime in on that?
I haven't seen anything else either.
Okay, well, it's pretty quiet. Well, based on the comment, our plan is to adopt these regulations and move forward per this hearing. So just for context, the next step would be we will be requesting that this be put on the Legislative Commission hearing agenda here in the next month. So we'll present it there, and then if all goes well, it will be fully adopted and we'll be in great shape by November to get that adopted. So this will be filed with an information statement to Legislative Commission hearing, and will be scheduled for a hearing date in the near future. But again, if there's anything, any additional comment that you want us to consider in that process, please send our way. And yeah, thank you so much for all of your work, for all of your assistance throughout this, especially meeting throughout the summer has been, I know, tough for folks too that are very busy. So we appreciate it, and we'll keep talking. Okay. It is 10:32, and at this point in time, we will conclude the hearing for R011-21. Thank you so much. Take care.